Okay, this is the third part of this lecture on the Bill of Rights, and we will start with this part with the Fifth Amendment. The Fifth Amendment covers 5 situations: subsequent prosecution after acquittal, subsequent prosecution after conviction, subsequent prosecution after certain mistrials, multiple punishment in the same indictment, and protection against compelled self-incrimination. This amendment says that a defendant cannot be tried for the same crime twice once there's been an acquittal or conviction, and there cannot be multiple sanctions for the same crime. However, there are a couple of exceptions to this. The first is that a person can be tried for the same crime in different sovereignties, such as state and federal. The retrial of 4 LAPD officers involved in the 1991 beating of Rodney King is an example. The officers were first acquitted by the California State Court and were subsequently charged and tried in federal court. In federal court, 2 of the officers were found guilty of civil rights violations and were sentenced to serve time in a federal prison. The other 2 officers were acquitted. Another exception to the double jeopardy amendment is in the case of military courts. A person can be acquitted in a civilian court and retried in a military court. Okay, here is an example. You have to tell me what you think. John Benton was tried on charges of larceny and burglary. He was acquitted of larceny but convicted of burglary and was sentenced to 10 years in prison. Shortly after his conviction, the Maryland Court of Appeals ruled that the portion of the Maryland Constitution which required all jurors to swear their belief in the existence of God was itself unconstitutional. Since the jurors in Benton's case had been selected under the unconstitutional provision, he was given the option of a new trial. In the second trial, he was found guilty both of burglary and larceny. Double jeopardy? What do you think? The Supreme Court ruled that the second trial was constituted double jeopardy. There was no protection against double jeopardy in Maryland from its state constitution, but the court ruled that the Due Process Clause of the 14th Amendment incorporated the double jeopardy clause of the 5th Amendment, and so made it enforceable against the states. As a result, the court overturned the larceny conviction. The Fifth also guarantees that in criminal cases, suspects or defendants cannot be forced to testify against themselves. This comes from the belief that confessions may not be truthful if they're not given voluntarily, and it expresses intolerance for certain methods used to extract confessions, even if the confession is proven to be reliable. The Supreme Court's, moving on. The Supreme Court's doctrine of fundamental fairness says that confessions are inadmissible if they were obtained by means of psychological manipulation or, quote-unquote, third-degree interrogation, such as beatings, long periods of questioning, or other physical tactics. In 1964, the court's ruling in Malloy v. Hogan case extended the Fifth to other states. Next case, the suspect was arrested on circumstantial evidence linking him to the kidnapping and rape of a 17-year-old woman 10 days earlier. The police interrogated him for 2 hours and finally signed a confession that said, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me." When the case went to trial, the prosecutor entered the confession into evidence. The defense objected, but it was overruled. The accused was found guilty and sentenced to 20 to 30 years in prison for each charge. The defense appealed to the Arizona Supreme Court on the grounds that the confession was not voluntary. The court upheld the lower court's decision, emphasizing that the accused had not specifically asked for an attorney. This case eventually found its way to the Supreme Court. The defense once again argued that the confession should not have been entered into evidence because it wasn't clearly voluntary. Well, you probably already guessed what this case was. It was the famous Miranda v. Arizona case. The Supreme Court reversed the lower court's decision. Chief Justice Earl Warren, a former prosecutor, delivered the opinion of the court, ruling that due to the coercive nature of the custodial interrogation by police, and Warren cited several police training manuals which had not been provided in the arguments, no confession could be admissible under the Fifth Amendment, self-incrimination clause, and the Sixth, right to an attorney, unless the suspect had been aware of his or her rights and the suspect had then waived them. So Miranda v. Arizona in 1966 broadened the protection to cover all custodial police interrogations that take place after an arrest, in or outside of a police station. If the suspect being questioned is not in custody, then what they say may be used in court. I remember when this was all happening, and police said that they couldn't convict criminals if this continued, which of course it did. Okay, the Fifth also applies to the defendant taking the stand. Not only does the defendant have a right to silence, but he or she has the right not to take the stand. Okay, so let's move on to the Sixth Amendment. This is the speedy and public trial by an impartial jury amendment, and it covers right to speedy and public trial, right to impartial jury where the crime was committed, right to be informed of the accusation, right to confront witnesses, right to compulsory process for obtaining favorable witnesses, and the right to counsel. There are two sides to the Sixth. The court has to weigh the behavior of both the defense and the prosecution. Delays can seriously hamper the defendant's case if favorable witnesses have died or moved or cannot be found, or if they forget what they witnessed. Defendants can also be affected by long waits in jail, which can be stressful and in some cases pretty dangerous. When I think of speedy trial, I think, yeah, right. However, the court has ruled that the right to a speedy trial is activated only when a criminal prosecution has begun and extends only to those persons who have been accused in the course of that prosecution. They also said that invocation of the right does not need to await an indictment, information, or other formal charge, but begins with the actual restraints imposed by arrests if those restraints precede formal charges. The Supreme Court has ruled that the seriousness of the case, as well as the reason for the delay, need to be factored into whether or not the Sixth has been violated. Currently, there are two separate time limits, one for the period between arrest and charging, and the other for the period between charging and trial. A delay of 30 days for the first and 70 for the second constitutes a violation. Okay, and we will move on to the last part of this lecture.